Thank you, everybody for joining us today. What we want to do today is to go through the question of if I can ask to mute, because somebody I can hear somebody. Please mute your microphone so you can hear me and Oleh Beketov. So what we want to discuss today is basically status quo, where we are on suits against Russian Federation. What about damages? What is happening with legislation, practice, and prospects? So today, me, Oleh Malskyy, and Oleh Beketov from Eternal Law, we will be conducting this seminar. We basically have the agenda with major blocks described, and let's start. If you have any questions, please do raise a hand or do interrupt, and we will clarify. So where we are today and what we see, what's happening. So basically, the key major issue about all claims against Russian Federation was sovereign immunity. Sovereign immunity is basically a concept where you cannot sue the state without either an exception or the state's permission to do that, right? And to the best of our knowledge, there are a couple of precedents. To the best of our knowledge, so far there was no claim filed either in the US or UK directly against the sovereign because of that immunity issue. So for 8-9 months now, everybody was trying to find that exception to sovereign immunity, and nothing serious came along. However, there were about 110 claims already filed against Russia in Ukraine, with about 16 decisions, mostly positive. So why it happened so? Because Ukrainian Supreme Court basically came to conclusion. It created a practice, a precedent, where it said that since Russia does not observe independence and sovereignty of Ukraine, sovereign immunity should not be granted to Russian Federation, and Ukrainian companies and physical persons are free to file claims in Ukraine against Russia. We will discuss it in more detail, but generally, about 3 months ago, 2-3 months ago, there were only 15 claims filed. Now it's 110, mostly physical persons, mostly moral damage, mostly small claims. But generally, we see this ball already starts to roll, and there are already some positive decisions with also in favor of legal persons. Some claims were filed to European Court of Human Rights. We will also discuss it in more details. We believe it's very long, but generally, quite a lot of companies have decided tick the box, file the claim until there is still a chance, because as we know, Russia was expelled from European Court of Human Rights, so maybe it's not very prospective. And there were some claims filed not against sovereign, but against basically private respondents, right? So you had a case filed against Wagner. If somebody doesn't know, Wagner is basically a private military company, employs about 5,000 private soldiers. There was a case filed against Total Energies in France, and there was a case filed against Prosus or Avito, which is basically it's a site basically that operates as a site, as a platform for hiring people, and it was basically claimed that the site contained advertising of jobs for soldiers. So there was a decision already to ban it. There might have been few investment claims, but we don't know because of cooling off period and because of confidentiality. So basically, there are some precedents to file not against sovereign, but to file against private companies. So those are the news, how you can pursue a private respondent. Again, we will talk about in more detail about this. I'm just giving you an overview where we are. So basically, right now, it seems that nobody has invented anything positive to go against Russia as a state in the US or UK. There's a snowball of cases starting to be filed in Ukraine. because Supreme Court has basically annulled sovereign immunity of Russia. There is a tendency to file cases in European Court of Human Rights. However, we do not see too much perspective in it. It's very long, and there are few precedents to go after private parties linked to the war. And there most likely will be investment claims, but it's very hard to track them because basically they are private and confidential. So again, elements to consider when you think about who respondent is. And first, you should be considered whether respondent should be a sovereign or a private respondent. And if you think about that, you have to also think about causality in essence. So if you have a sovereign respondent, right, this can be Russia or Belarus, right? Now everybody's forgetting about Belarus, but they can also be a respondent. You have to think about causality. For Russian Federation, it is presumed, right? So everybody is clear that causality is there. For Belarus, it's a question mark. So maybe nobody goes against Belarus because causality is still an issue. And again, the Ukrainian Supreme Court has already annulled sovereign immunity for Russian Federation, but has not done so against Belarus. So, perspectives are much less. Assets. Basically, you would look for assets which are not sanctioned or blocked, which are not pledged, and are not covered by diplomatic immunity. We will focus on assets a bit later, but generally, I would make a remark here that sanctions is a bit undefined beast. The way we see it, sanctions are something like a lien on assets, something like a block. And there's no clear answer yet whether, if you get a court decision, whether your court decision will prevail over that lien or not. That's why best case scenario, you find an asset which is not covered by any of those three categories, which is not sanctioned, not pledged to a bank or anything, and does not have a diplomatic immunity. If you go after private companies, who that may be, right? That may be a state companies, right? State companies belonging to state of Russia. That those may be private companies which are involved in such a conduct that may be supportive to war. Those can be sanctioned persons, but we may have issues with the sanctioned assets. But causality is difficult. You need to have you have really to prove that those private parties are involved and have been causing damage to you. There may be high legal resistance, right? So there may be additional costs. If we saw from previous precedents and even now that Russia may not be participating in many legal actions, private persons may be participating, and they do have separate legal budgets to fight. So it may be more difficult. Again, as to assets, you would be looking for non-sanctioned, non-blocked, and non-pledged assets. I will just share a bit of light of one potential private respondent we are considering right now. It's a company called Headhunter. We have not yet decided how to proceed, but I'm just showing you an example of potential private respondent. Headhunter is basically a big Russian company. It is listed in New York, so Nasdaq listed, listed also on some other exchanges. Headquarters is in Cyprus. Its assets are claimed to be roughly 300 million USD. And what it has done, right? So basically, it's a recruiting site which basically lists jobs for Russian soldiers to go to war in Ukraine. Here you have a claim, citing basically from BBC saying that there were more than 6,000 listings on this site to basically advertising jobs to go to war to Ukraine. Currently, there's a advertising of a job to go to Zaporizhia nuclear plant, for instance, on this site. So we are really thinking whether we can say there is a causality there, that this site basically helped to involve Russian soldiers, hire Russian soldiers to go to war in Ukraine. So this is a potential example of a private respondent. If we think about assets, a lot of people are thinking about assets, and key question is, okay, if we even get the judgment, whatever, Ukrainian judgment, foreign judgment, arbitration judgment, what do we look for? How do we enforce? This question is also asked by many litigation finance funds which are considering basically financing such claims. They also have a question: how do we get to the money? And as I was mentioning, what those assets can be, how do we get to them? So if it's sovereign, you should be asking whether those assets are sanctioned or not, whether they are pledged or not. Here you have in brackets, you see Gibraltar. There was a precedent already where a yacht was sanctioned of an oligarch, but it was pledged to the bank, and the loan was given to the oligarch to build this yacht even before the war. So basically, a bank, it was either Morgan Stanley or a huge American bank. They had to go into litigation. Then they won 3 instances in Gibraltar, and basically Gibraltar said that if there is a pledge, it supersedes the sanctions. So you have to be careful if you run after assets. Double check in the registers; they are not really pledged as collateral under some credit loan agreement. Diplomatic immunity, of course, but there are other assets where to look. So first of all, there are receivables, right? So if somebody owes money to Russian Federation, this is a receivable. It may be arrested, may be enforced upon. There are some bonds which Russian Federation holds in other companies, shares of companies. There can be real estate, and I particularly love paintings. Right? There may be some artwork which is quite valuable. If you go on after non-sovereigns, right? So we ask the same questions. Are those asset sanctions? If they are sanctions, can we use them? Is causality assumed? There's also a question of criminal path, right? What is criminal path, and why, for instance, somebody filed a claim against Wagner as a private military company? And there is a thing called POCA in the UK. So basically, POCA is a proceeds of criminal act. It's a UK act. Basically says if you can prove in a criminal procedure that some person, specific person, is the reason, has caused damage to you, and is guilty in a criminal procedure established, his guilt is established in criminal procedure, you can enforce on his assets if they are, for instance, in the UK. And this is basically an exception to the sanctions, right? To other blockage of pledges. So there is a path that you can basically try to prove. For instance, everybody knows that who Wagner is, and then who is the person that is sanctioned there. So if that person has assets in the UK, for instance, and if there is an established guilt in criminal procedure, that may be a path to do it. What other Western countries are doing, right? The donors, they are thinking about a fund, and we know that yesterday there was a UN resolution. Again, as all UN resolutions, the wording is pretty bright, but there was a UN resolution already on thinking what to do with this and thinking how to do a fund. Canada has already taken that path and basically said we will expropriate everything which is Russian, put it to the fund, and proceeds of that fund should be used for restoration, reconstruction, rebuild, upgrade of Ukraine. We believe there is a risk of VAT claims or nationalization claims against such donors. Right? For instance, if France were to take everything Russian in France, Russia may take everything French in Russia. Moreover, Russia can sue France for nationalizing all Russian assets. So unless there's really a kind of a treaty, international treaty, most likely which Russia should join, which we do not believe will happen, this may be a very difficult thing to do. So Here's a print screen. Yesterday, General Assembly of UN has basically approved the resolution regarding the reparations to Ukraine from Russia. It sounds a bit as a done deal. It's not. Basically, the wording is very wide, very weak. Basically, it says we should consider this issue. But if we go back to where the assets are, this is my favorite article. If you look at the picture behind this guy on your right, maybe you left it because you look at it differently. You can see the Picasso painting, girl on the ball, famous one, everybody knows it. The article basically says there are about 400 paintings of Russian museums stuck abroad. So this is an example of a perfect asset, right? So asset which is not pledged under sanctions, assets which does belong to Russian Federation because it belongs to Hermitage. Right now, most of those paintings are really exhibited outside of Russia. So the valuation of those 400 paintings is huge. Nobody has done it, but you know that Picasso painting alone, I think, would cost a couple of hundred of millions USD. There are also paintings of Renoir and others. So that's an example that the rise is there, right? You can chase, and you can think a bit outside of the box to chase them. This is a map of yachts of oligarchs, which were sanctions or blocked right now. Again, there's a question whether you can you can prove causality of those oligarchs. You can take the position that since they are in sanction list, somebody has already done the job and proved that they are so close to the regime that the causality is basically assumed. But again, nobody has tried it yet. If you look at the map, Finland seems to be a very interesting place because there are lots and lots of yachts sanctioned and frozen and blocked in Finland. So if you think about where to enforce, maybe Finland is also a good place. Okay, so if we go back to legal, so let's assume you have a claim, right? If you go after private respondent, most likely it will be courts. It can be Ukrainian courts, it may be courts of jurisdiction where that respondent is established. Causality will be the key question. How you prove that private respondent is linked to the damage it has caused. Does that private respondent have assets? So you have to do the check, etc. Then the next question will be, what's the best forum? What's the best forum for that? Substantive law. We believe substantive law should be Ukrainian. It's a place of damage, right? So place of damage. You should also think whether injunction, freezing of assets, is possible in that action. Theoretically, yes, and that will be a huge benefit. If you think about sovereign, and this is where I would pass the floor to my dear colleague Oleh Beketov. If you think about sovereign, option number one is go to Ukrainian court. So Oleg, can you hear us? Can you take over from here?
Yes, Oleg, thank you very much, and it's my pleasure to participate in this very important event, I believe, for both our law firm and for all colleagues who are taking part in it. And thank you also for your presentation, which you made. We have with Oleg one presentation in common, so I will ask him to scroll from file to file and to assist me with my presentation, actually. As Oleg have already mentioned, one of the biggest, if not the biggest issue in suing Russia in various jurisdictions, and this also had been an issue with Ukraine's jurisdiction, is sovereign immunity. And the concept of sovereign immunity is well known, and it says that, the court of one jurisdiction cannot sue the country of a different jurisdiction, which actually means that, for instance, Polish court cannot be the forum for resolution of disputes against Russia Federation, but, likewise, Russian court cannot be a forum for resolution of disputes against Poland unless there are exceptions to this rule. And these are exceptions well established by private international law rules. And among them is just, for instance, the consent of the states that is sued in a different forum. But, it's definitely would not be the case with Russia because, we highly doubt that Russia would give any consent to being sued either in Ukrainian court or Romanian court or the other court. So in this respect, the task which was before the Ukrainian courts the spring of this year, when the aggression started and many lawsuits were filed against Russia and Ukraine, was also how to overcome sovereign immunity given Russian aggression against Ukraine. And there was one very important case which was filed by one individual who actually lost first two instances, the first instance and the appeal instance, and the loss was exactly to the sovereign immunity because Ukrainian courts of lower instances, relying on private international law and the same principle which I have just discussed, says that unfortunately, Russia cannot be sued in Ukrainian courts due to principle of sovereign immunity, which is fixed in the private international law of Ukraine. But when the matter went to the Supreme Court of Ukraine, the Supreme Court actually lifted sovereign immunity, and it was the first decision, I think, in the world in this respect. And it's logical because, aggression is against Ukraine, where, Ukraine Supreme Court says that Russia cannot have sovereign immunity in Ukrainian courts because, to have sovereign immunity, the sovereign should take steps and should actually execute its sovereign will according to international law. But what Russia is doing is actually not proper execution of its rights under public international law. It's military aggression. And in this respect, the consequences of this military aggression should be that, Russia should not be granted sovereign immunity. And in this respect, decision of Ukraine Supreme Court was substantiated by several international law treaties like European Convention on Sovereign Immunity of 1972, which provides actually as an exception tortious actions of one state on the territory of other state. So in this respect, actually, the Supreme Court of Ukraine said that, given that actually military aggression of Russia is actually tortious conduct under Ukrainian law, because actually by doing military actions, Russian army forces as agents of Russian state, they cause harm to Ukrainian citizens and Ukrainian state and Ukrainian businesses, then in this respect, such acts of harm should not be granted by immunity protection. And we received an option in this respect how to go forward in our claims against Russia. And we already started several actions on behalf of our clients in Ukraine. And the best mechanism which we anticipated and which is workable right now is to file a claim against Russian Federation with Ukrainian court, and then to have decision of Ukrainian court recognized and enforced abroad. I should say in this respect that, as of today, even so, as Oleh mentioned, there is a good number of litigations pending in Ukraine against Russia, and even there are 16 decisions rendered against Russia already, but we are not familiar with any precedent where Ukrainian court decision has been already recognized and enforced in foreign jurisdiction against Russia. And this is the part of the job to be done by Ukrainian law practitioners. But we believe that there is legal framework for such recognition and enforcement because Ukraine, first of all, Ukraine is a party to a number of bilateral treaties between Ukraine and other countries. Like, for instance, this bilateral treaty which anticipates mutual recognition and enforcement of court decisions of Ukrainian courts in Poland, in Czech Republic, in Cyprus, and some other European jurisdictions. And also, Ukraine is a party to multinational treaty, but it's like, unfortunately, CIS treaty, Minsk Convention. Of course, we exclude Russia, but there are some other countries like Kazakhstan, Uzbekistan, but we doubt that they will be favoring Ukrainian decisions against Russia. But at the same time, there is also possibility to enforce Ukrainian court decision in a number of foreign jurisdictions if this will be this will be money judgment. And such possibility is provided, for instance, by local legislations of respective states, for instance, by United Kingdom, by Switzerland, by United States. They all have acts which allow enforcement of foreign court judgments, if these judgments are about compensation of damages in monetary reform, and not, for instance, some declaratory judgments like when, on the basis of Ukrainian decisions, there might be some title issue in Switzerland. Such a decision, of course, will be not recognized, but, if the decision is purely in damages, in money and in the form of money, it may be recognized. And in this respect, of course, the big issue is still sovereign immunity, because the fact that Ukrainian court lifted sovereign immunity in Ukraine does not mean that this decision has any extension on future decision of Polish or Swiss court in respect of recognition and enforcement of Ukrainian court decision in respective jurisdiction. But, I think there are some positive developments in this respect, because you can see that the number of countries recognize Russia as a terrorist state. And there was a decision from Parliamentary Assembly of Council of Europe. And there are also many discussions in the United States about also recognition of Russia as a terrorist state. And why it is important? Because it is important in a sense that, the country which is sponsor of terrorism cannot have, protection in the sovereign immunity, because protection, as I mentioned in the beginning of this slide, that the protection for sovereign immunity is granted to the state who properly actually executes its rights and duties under public international law. And in this respect, the countries provides some committee, some respect to, on the basis of principle international committee, other countries, provide some respect to the state, that they do not want the state to be prosecuted in their courts. But this is not the case with a state who is sponsor of terrorism, and where, decision of the court is actually the outcome of this terrorism activity. Because as Oleh also shown some slides, there was a building in Kyiv, private building, which was destroyed as a result of Russian attack of civil infrastructure in Kyiv. And this is exactly the act of terrorism, and the harm is a consequence of this act. Then, I don't see logic why such court decision for compensation of damages as a result of terrorist act should not be recognized in a normal European jurisdiction and should be protected by Russian sovereign immunity defense. Well, maybe you can go to another slide. Another option actually to circumvent sovereign immunity is, of course, BAT investor claim. Between Ukraine and Russia, there was UA-Russia Treaty on Mutual Protection of Investments. This treaty was made in 1998, but it covers investments made in both countries from 1992. And actually it provides all mechanisms under public international law regarding protection of investments. Why this treaty is also important? Because actually, as a result of various annexations which are made Russia, of course, we are discussing de facto annexations, not annexations in legal sense. There were various precedents. First of all, with Crimea, when assets of Ukrainian businesses were in fact nationalized by Russia legally on the territory of Ukraine. But by making such expropriation, Russia actually assumed its obligations under public international law. I mean, obligations in the sense of liability, because actually there was expropriation on the territory of Ukraine, but it was de facto controlled by Russia. An asset was de facto expropriated by Russia. Russia is liable under public international law for this expropriation. And there was very big case of Everest Estate LLC versus Russia Federation pending in arbitration. And for about 2 years, there was an issue of investor status, whether in fact Ukrainian company with Ukrainian ownership can have standing against Russia, given that under public international law, Crimea is a territory of Ukraine, but de facto Russia controls this territory. And the issue was resolved very good for claimant, and I think for any potential claimants, that if Russia has de facto control of the territory and expropriation happens of a territory which is controlled by Russia, at the time of expropriation, Russia is liable in public international law for this expropriation. This means that in other situation where, you know, Russia also officially declared some extra territories to be joined to Russia, and these territories are also de facto controlled by Ukraine, we may say that, in fact, Russia Federation assumed international responsibility for, for property, for various businesses, for lost profit, for other stuff which happens over this on this territory, sorry, within pendency of Russia control over these territories. And you know, the interesting question is actually, given, you know, Ukraine's successes over this war, whether the status, this de facto control, is applicable over territories which are controlled by Russia permanently, I mean, for some more or less long period of time. Or control may be, or I mean, definition of control may be enough for control over a short period of time, like for instance, over 1 month or less, over a few months. Because, you know, in this respect, you know, situation was very different. For instance, if we take as an example, Kiev region, actually, Russia occupied Kiev region over a period of over 1 month. And if you take example of Kharkiv or Kherson regions, you know, the period of occupation was for several months. But if you take example, for instance, of other territories, they unfortunately still occupied by Russia. And, you know, the good question is, you know, to what extent Russia is liable for investment loss over these territories. You know, I may only express my personal view because actually there is no right now precedent like this Crimean case. I mean, decision made by international tribunal, arbitration tribunal, you know, setting some guidelines in this respect. But, you know, my personal view is that if during period of control of some Ukraine's territory, there was either expropriation of business, like for instance, you know, Russia expropriated some goods or actually stole some piece of arts or something like that, then it may be at least argued that, you know, within the period of control, Russia expropriated property of investors, you know, of who actually were owners of this property before control. And Russia should be liable in public international law for this expropriation. If, however, you know, there was no expropriation, like for instance, you know, there was control of a territory, but there was some plant, for instance, a factory, which was not ruined during period of war. It may be hard, you know, to argue that, you know, there was, in fact, the fact of expropriation because, you know, Ukraine liberated territory and, you know, your property is still there. And it, of course, may be very difficult to say, I mean, within ambit of public international law, that Russia should be liable for instance, for lost profit. I mean, in a sense of investment claim. You know, we may say that, you know, Russia may be liable in tort claim, I mean, going to Ukrainian court, but whether, you know, you may effectively say that, you know, expropriation extends over your lost profit claim because, you know, your factory was occupied for several months, it was not destroyed, but the territory was liberated. It's a very big question mark. And in this respect also, I think that there may be some distinction between territories which were occupied and liberated by Ukraine, but which were not officially recognized as Russian territories. And those territories which were liberated by Ukraine, but which were recognized by Russia, still recognized by Russia as their territories. Like in this respect, you know, Kherson is a very fresh example. Because, you know, in any event, you know, it may be said that, you know, by making these acts of annexation of territories, you know, Russia assumed liabilities de facto assume liabilities for what happened with these territories. For these reasons, in my view, it will be much easier to prove with an investment claim that Russia is liable, for instance, for some part of territory which is on Russia constitution is considered as Russian territory. Of course, it's not recognized by Ukraine or any other state, but by making this amendments to its constitution, Russia actually de facto assume liability for what happened on this territory, rather than for instance to impose liability over Russia in respect of the territory which was not annexed by Russia but which was liberated by Ukraine. Like, for instance, in this respect, Kharkiv region is also a good example, because Kharkiv region was under occupation for several months, but Ukraine actually deoccupied this region, and it was not joined as a subject to Russian Federation. So maybe the next slide. I will take this one and pass word to Oleg. The next option we considered in respect of how to circumvent sovereign immunity is applying to European Court of Human Rights. But as you know, Russia actually declared that it would not be longer party to Council of Europe. And it's also, in this respect, it also means that it would not recognize any more jurisdiction of European Court of Human Rights. And there was, some deadline for claims made against Russia in this September. And many people, in fact, they file claims against Russia to ECHR, but, there are two issues in this respect. First of all, it's, to litigate any claim in ECHR, it's a very, very long process. We had one practical example with Oleg, where we represent client who also lost investment in Crimea, and he opted to go to ECHR. But it was his decision, not our advice. But even though ECHR established jurisdiction over such claim, we are still waiting for decision, and we in fact applied to ECHR in 2016. So it's very, very long process. And also, given Russian attitude to European Court of Human Rights and Council of Europe, enforcement is very questionable, because even before Russia decided not to be a member of Council of Europe, enforcement of ECHR decisions in Russia was very, very difficult, and they were maybe the only one country in the Europe being member of European Convention, saying that Russian courts can revisit decision of European Court of Human Rights and not to enforce them if they contradict, for instance, Russian constitution. So we believe, it's a very difficult option to pursue. Other options, and they are of course theoretical, but what was discussed a bit by Oleg, and I will briefly outline them, is actually also to apply to UK, US, or other courts, but foreign courts, and try to litigate Russia there for damages caused in Ukraine. But there are the same difficulties which Oleg outlined in his presentation. In the first place, immunity exception will be very difficult. We discussed this issue with many lawyers from the UK and the US, and the practical advice was that unless either US Senate or UK Parliament or other, for instance, European Parliament, Parliament of any European country like Switzerland or Polish Parliament would adopt an act saying that immunity against Russia should be lifted for such type of claims. It's not possible to apply, and most likely Russia shall be protected by immunity exception. Also, if you go to the US court or UK court, you need to show a nexus requirement. You need to show why you go there instead of Ukrainian court, because actually, if you are even foreign investor into the territory of Ukraine, but your investment was actually destroyed by Russia on the territory of Ukraine as a result of this war, the proper forum for this is Ukrainian court. Even if you will be able to say that you are governed by rules of personal jurisdiction in foreign court, like for instance UK court can exercise over your jurisdiction because you are, for instance, British company which owns assets in Ukraine. And there may be, a very big stage of litigation where you will be proving that, UK court is appropriate forum to try such kind of case if, damage caused on the territory of Ukraine, Ukrainian law is applicable to such relations, witnesses of this damage are located in Ukraine, and most of the, evidence is also located in Ukraine. And in such type of cases, for instance, as we litigate right now in Ukraine, it's also very important, some documents and statements from Ukrainian military, showing, that in particular regions there are military actions, which particular Russian troops participated in those actions, and how actions of those Russian troops actually led to particular damage. So I doubt that, UK judge in such case would be inclined to resolve such actually complex case as for him, as having only one nexus is actually claimant, and having no other possibilities to resolve such disputes, either, from legal standpoint or factual standpoint. And another option, as Oleh mentioned, is, criminal jurisdiction, but, it's a bit different stuff because it is governed by local rules of criminal procedure and governed by local criminal statutes. The only thing I may say is that, any criminal law cases, they are very long and complex in any jurisdiction. And if there is some, personal nexus, to the case, like for instance, you are US citizen, UK citizen or US citizen, or you are Ukrainian refugees there, and you believe that there was a criminal act against you, like for instance, your relatives were killed, and you seek compensation of moral harm, but you also seek, some moral satisfaction out of this redress. I would advise to pursue this option, but, bearing in mind that it will be also difficult and long. But if your business and what you are just looking is money, I would actually opt for different options and either suing Russia in Ukraine or go to to investment BAT treaties, or actually thinking about thinking about some lawsuits against non-Russian actors, non-Russian state actors like Wagner, like others who actually are not governed by sovereignty immunity protection. But if, as Oleh properly said, if you're able to prove causality against them, you still will be able to litigate against them effectively and get enforceable award. I pass word to Oleh, and I will come back.
Absolutely. I think Oleh just absolutely greatly summarized it. I would only add that it really also depends very much where your damage is and where your asset is located. So if your asset is located on the newly annexed territories that are still under control, or were at least under temporary control of Russia, I think that BAT claim, the investor claim, is the strongest because there is a precedent. However, you have to understand that it is most likely the longest, right? It is pretty long. The precedent we described, it was filed, I think, in 2015 or 16, and it took quite a while to get the jurisdiction discussed, to get the decision rendered. And again, even if you get the arbitration award, investor award, it still takes a bit of actions to enforce it. It can be challenged. In that case, Russia did not participate in arbitration itself, but it challenged the decision, tried to set it aside. However, both Swiss courts and Dutch courts confirmed this decision should stand. So if your asset is located in the newly annexed territories or close to them, or was under temporary control and you suffered damage during the temporary control, investor arbitration seems to be a good way to go, because there is already a precedent of that. And there is a very high likelihood, like 90% likelihood, that the facts are the same and it should be quicker, but the precedent is there. If, on the other hand, your assets are not on those territories or you suffered other damage, it seems that the best way would be to go to Ukrainian court, get the Ukrainian decision, and then try to enforce it outside of Ukraine, for instance, in Poland, where we do have the convention of legal support and where recognition may be easier. Poland is also very pro-Ukrainian politically wise. Maybe we can consider Finland because there are lots of yachts there. Maybe we can consider Canada, which is also very pro-Ukrainian. But those two options, either Ukrainian court or investment arbitration, seem to be two preferred options from practical point of view, depending where your damage was, depending where your asset was. Now I would like to turn quickly to litigation finance funds, what that is, how it works. And I would start from a question: what do you do if you're 100% right legally? So you have a strong case, but you have no money for court fees, lawyers, security for costs, others. And does it create a problem with access to justice? And since this was an issue, so even if you're right that you're poor, it seems that you have no chance to stand in court and prove you're right. So litigation funds were created quite some time ago. Some of them are already like 20, 25 years old. What they do, they basically finance your case. So they take over your expenses and do the legal work. And once you're a winner, they will take a piece of that action. So basically, a success fee on a contingency fee basis. And the process with such funds is that they source litigation cases, they assess those cases on merits, basically estimate the chances of success and estimate the cost of required to do that such a case. Then they provide financing based on that on that valuation, and then if the plaintiff is successful, they receive a portion of a award after collection or the portion of settlement if there's a settlement. I have to say that we already have worked with one or two of such funds. We are at the beginning of it, but funds now, actually, at least one fund we work with is pretty much interested to look at the cases and decide whether to fund it or not. So we are there with the funding experience, and something that may be discussed. Of course, funds would love to have big cases. The bigger the case, the more interesting it is for the fund. But we've managed to persuade the fund we work with that they should also look at the cases which are not that big, starting from 1 million euros, which funds typically do not take. But this is also an option to consider. Difficult question is class action and assignment. Can you group those cases in a class? And frankly, there's no clear answer to that. Of course, you do have the right to assign a claim. Assignment may be possible, and this is maybe how you group them. Maybe it makes sense to assign already not the claim but the award. So get the Ukrainian judgment, get the European the investment judgment, and then assign the right of demand after you have already received the claim. Class action is not really very popular in Ukraine. We do have issues that sometimes the facts are different. Now, for each case, there were a couple of precedents where you had NGOs as a claimant. So there was a BRSM case where there was a disaster, ecological disaster, fire on one of the refineries, and basically that's the first precedent where you basically had NGO get together all the people who suffered moral distress and bring one claim in the name of all of those participants. But that was very ecology specific. You can do that in ecology cases, not really in others. I talked about Avito case. Avito was basically the case which was reviewed in Denmark. Sorry, not Denmark, Netherlands, Dutch case, Dutch court. We helped a bit an NGO with that case. Basically, outcome was that a court said that there is a duty of care and Avito site should stop announcing positions for Russian soldiers to go to war in Ukraine. But that was also done under Dutch law through an NGO that was specifically formed for this case. A famous granny just wanted to be a bit boastful. We do something for common people as well. If you know, this granny was saved from the ruins of a building of her apartment on Zelenska Street in the very center when there was another attack, and we managed to get to the granny, and we are now representing granny against the state of Russia, try to get some moral help and moral distress of that. So just wanted to point that out, that I'm happy that we can help the granny. Thanks a lot for your attention. Our emails are there. I would love to get some questions. We have almost done it for 15 minutes now, so I would love to have some questions and share some insight. But generally, I think that our main aim was to show you where we are, what's the status quo, who does what, where, how successful it is, what were the precedents, and give you some recommendations. We summed it up. Two most probable and seems to be reasonable ways forward will be a Ukrainian court with future recognition and enforcement abroad. We showed you some assets of Russia. It's not an empty box. You can still chase them and get them, or to have an investment dispute and take that road, especially if your assets are in southern Ukraine, eastern Ukraine, on the newly annexed territories, or were for a long time under de facto control of Russia. And we also discussed a bit funding. So if you believe you should use the funders, that's also an option to consider, because it's contingency based, successfully based, which provides a good way out. We will share the presentation afterwards. So I will close the window. If you have questions in Ukrainian, feel free to pass it. We'll switch to Ukrainian because there are a few colleagues for English-speaking colleagues. That's why we record the session and we did it in English. And whoever asks the first question will get a coupon from Eterna for 3 hours. Nobody wants a free coupon. Okay, did you like it? Are there any questions? Dear audience, it was a small event for just 10, 11 people.
Oleh,
yes,
Oleh,
Peter.
Thank you very much. That's very enlightening for somebody who's not a lawyer, and very interesting. And I think I could speak for my colleagues here by saying that we'll discuss this and come back probably with more detailed questions about where we should start in our own particular case with the Kherson assets, which is our biggest loss area. So no questions right now, but we will be back in touch. Thank you very much. Very interesting.
Super. We like that you like it. Super. Good. Okay. Dear all, if there are no other questions, feel free to email. We will send over the presentation so you have it, and we'll be happy to help. You know that the types of damages you may have, as I said, direct damage or kind of destruction damage or expropriation damage, but you also do have the lost profit. You also have something like non-payment from occupied territory. So it should be all combined and reviewed. Right now, you do the right thing if you fix it, right? If you take all the witness statements, if you do everything you can to document those damages, and we are here for you to help. So thanks again for joining, and have a good day. Good.
Yeah, I mean, on the end also thank you very much to everybody, and just to add a bit to all, it's extremely important, the option which you would pursue, because as we already outlined in our presentation, there are indeed many options to go forward with your claim, but you need to consider which option to pursue, because one option may bring you quickly to the outcome, whereas the other option may put you into litigation for many years, which is not bad for us as lawyers, but we care about you as our clients and potential clients. And in respect of Russia, we indeed want success story, because this is not success story for those who suffered from the damage, but this would be success story for all of us and for Ukraine.
Absolutely. Thank you for the initiative, because basically Ivan and Peter were saying, guys, you do so much for it. Let's get together and then do the seminar. So Ivan, Peter, again, thank you for pushing us to do this. We love it. So yeah, we hope it will be helpful. And I really want that painting. That Picasso painting is my goal. So we should collect it. Get a good case and collect it. Good.
No, thank you. Very insightful.
Thank you. Yeah, thank you guys. Super. Thanks. Have a good day then. Yeah. Thank you.
Bye-bye.
Bye. Bye. Bye.